Welcome to the noon meeting of the Rotary Club of Baton Rouge. Before we start, please remember to silence your cell phones so they don't interfere with today's program. The invocation will be led by Don Takazis, the pledge by Barry Blumberg, and after the pledge, please stay standing for the four-way test.
I invite you to pray with me. Our God in heaven, Father of us all, we're grateful for the privilege of serving and being leaders in our community. We meet today to grow in our capacity to serve above our own individual needs. Help us to be mindful of the needs of others, to be doers in our communities. Help us to lead by the four-way test and be active participants in truth and our concerns for each other. We ask your continued presence on those still recovering from storms and strengthen those battling the pandemic. Thank you for the conversations around the table that will deepen our friendships. Thank you for our speakers today that will expand our knowledge and help us grow. Bless the Rotary Club of Baton Rouge. I pray in Jesus' name. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
The four-way test of the things that we say, that we think, say, or do.
Is it the truth? Is it fair to all concerned? Will it build goodwill and better friendships? Will it be beneficial to all concerned? And now Tina Holland will introduce today's guests.
Good afternoon. Please join me in welcoming the following guests. Roger Fleshman, the guest of Mike DePaul. Leanne Clemens, the guest of Liz Hampton. Bill Bryan. Jordan Holtberg, guest of Sean Kirkland. Erica Green, guest of Alicia Murphy. Will Chapman, who's not here. Matt DeVille, guest of Maui Taki. And Dave Peterson, Steven Sanchez, Eric Troutman, guest of Kelly Troutman, and Nina Fleshman, guest of our speaker, David Fleshman. Welcome, all of you. Thanks for being with us.
Welcome. And now Barry Blumberg will introduce our newest member.
It's my pleasure today to introduce our newest Rotarian, William Dory Binder. Dory is retired from Women's Hospital as the Chief Medical Officer. Dory began his career in Baton Rouge as an obstetrician gynecologist in private practice. He moved from there to the Louisiana Women's Healthcare Associates, and from there as medical director to Women's Hospital, and finally Chief Medical Officer at Women's Hospital. Dory, if you can't find him, he's got 3 grandchildren, one of which lives in Colorado and the other 2 in New Orleans. So if you're looking for him and can't find him, try New Orleans or Colorado, and that's where you'll probably be able to find him. Please help me welcome our newest member.
Dory, welcome to the club. Today's head table, to my right, your left, Barry Blumberg, President, Blumberg and Associates Incorporated. Dory Binder, our newest member. Jan Ross, Executive Vice President, Philanthropy, Huey and Angelina Wilson Foundation. Don Teakouts, Commanding Officer, the Salvation Army of Greater Baton Rouge, who led us in the invocation. I'm Maui Tachi, your club president. David Fleshman, our speaker, one of our speakers. Christine Cowell, our other speaker. And Robert Atkinson, partner, Breazeale, Sachse Wilson, L.L.P. Your head table. On Wednesday, October 6th, our guest speaker is Dr. Willie Smith, BRCC Chancellor, and he'll be speaking to us, giving us a BRCC update. And on Wednesday, October 13th, our speaker is Jay Daniels, Chief Executive Officer of East Baton Rouge Housing Authority, and he will be speaking to us about rethinking housing. I want to give you an update from the Technology Committee. You'll see President-elect Shard Richard is sitting at the Technology Committee today. I want to ask all of you to look to join the Technology Committee to help out. We simulcast all of our meetings via a service where it goes to our Facebook and YouTube feed, and people around the world watch our meetings. And so we'd like to get more members to join the Technology Committee to help out. And you can see with Thomas Brown is our first. He says he's going to help next week. So I don't want to see where the feed goes. So I want to thank both David and Christine for speaking to the club. Every week, our club donates a book in your honor, in both of your honors, to Crestworth Elementary. And this week, the book is Frightville, #1, Don't Let the Doll In, by Mike Ford. And now, before we start, remember, if you're not eating or drinking or speaking, please keep your masks on. And Robert Atkinson will introduce today's speakers.
Thank you, President Maui. I suspect that at least a few of you know that on July 1st of this year, the National Collegiate Athletic Association adopted rules which enable college athletes to use their name, image, and likeness to make money. Not surprisingly, both for the athletes and their potential entrepreneurial partners, the devil is in the details. I know nothing about the topic beyond the fact that NIL stands for name, image, and likeness. But my colleagues, David Fleshman and Christine C.C. Colwell, are well versed in the topic. David earned his undergraduate degree from LSU and was a member of the LSU basketball team. Following his perhaps less than storied basketball career, David attended and graduated from LSU Law School in 2011. And David joined our firm in 2019. David practices in the rapidly evolving area of sports law, and David is an adjunct professor of law at LSU, where he teaches sports law. Before attending law school, Christine Colwell earned a master's degree in sports management and spent her entire undergraduate, graduate, and law school career working in college athletic departments. While at LSU Law School, Christine was selected to serve on the Louisiana Law Review. Upon her graduation in 2019, CC joined our firm. CC also practices sports law and is well versed in NCAA rules and regulations. It is my honor to welcome both David and CC to our club. Thank you.
Thank you, Robert. And with some of that height, I could have had maybe more of a storied career and done more playing than practicing. But thank you very much. We are both excited to be here. Joining me today is CC Colwell. We both practice in the sports law realm. We have been studying NIL for the past year and a half before it really hit the news and before all of the changing and ever-changing landscape. Really, people knew about that at all. So, today what we're going to do is we really want to introduce what are we talking about when you hear NIL. My mother's here today, and on social media, she's asked me just a few days ago, what is NIL? So I figured we'd bring her along with us today on this journey. So we've got some presentation material. We have contact information up there, but feel free to contact. We had it on there. There we go. Feel free to contact us if you have any follow-up questions. And we're going to try to move through this quickly so that we'll have enough time for people to ask those burning NIL questions that they've been dying to ask. So first, what are we talking about when we talk about NIL? What is NIL? As Robert correctly said, it is name, image, and likeness. Okay, those are the three elements that make up the legal concept known as the right of publicity. All right, the right of publicity involves those situations where permission is required of a person to use their name, image, and likeness. Okay, so some examples of name, image, and likeness activities include autograph signings, making personal appearances, giving speeches, social media posts and endorsements of products, and video games. Okay, historically, as many of you know, the NCAA has prohibited student athletes from endorsing products or for making money on their name, their image, and their likeness. And that included even if that student athlete was not going to be paid, they still could not endorse another product. That all changed on June 30th of this year. And Cece is going to walk you through briefly here kind of why that changed and how we got to this crucial point of June 30th, 2021. But this has been described as one of the most transformative changes in college sports in the last half century. It's also been described as the Wild Wild West. And one of LSU's athletic directors even described what her compliance department is trying to do. It's like building an airplane while in flight. So if you are confused about NIL, not sure really how it all fits together, maybe how it works with your business, and whether your business is even interested in pursuing it, we hope to answer some of those questions for you. But we think it's important for you to understand how we got here, because this is a fight that's been going on with the NCAA and student athletes for decades.
All right, so we're just going to walk through a bit of the history. We're not going to get deep into the details. David, I could talk about this for like 3 hours. So basically, the courts have faced many challenges from student athletes trying to gain the right to profit from their name, image, and likeness for many years. It wasn't until 2019 when then we had state legislation come about. So the first state to propose or pass any kind of bill was California. They did so 2019. The only thing is it wasn't effective until 2023. So while we put it in place, the NCAA still had some time to kind of figure out what were they going to do with the state legislation once it became active. So they finally, in October of 2019, committed to creating policies and procedures as to how student athletes would be able to profit from their name, image, and likeness. We, sat around, wait a little bit, nothing happened. Florida in June of 2020 passed a bill which became effective July 1, 2021. So at this point, the NCAA was put some pressure. They had a year to figure out, are we going to allow states to continue to pass legislation that's going to give student athletes the right to do something which is legal under state law, but prohibited by the NCAA. So you have then the confliction between the policies. So at that point, the NCAA said, okay, we'll create policies and procedures actually by January of 2021. So they were scheduled to vote at them at their national convention that happens once a year. David and I were anxiously waiting to see what happens, and they tabled the vote. They cite, several reasons why. Some external factors, including there was federal legislation that had been proposed at that time. So, why do anything yet if there's going to be a federal bill that's going to trump everything? Then we had the Supreme Court granted cert in a big case, which I'm sure some of you guys have heard of. It's the Alston case, which the decision actually came out June 2020, which was a huge blow to the NCAA in regards to the amateurism principles, which is what this is all kind of based on. So the NCAA kept, holding off, didn't want to do anything. Nothing like waiting till the last minute, because you have states then continuously passing bills, which we will get to in a couple of slides as to how many started then implementing legislation to be effective July 1. That June 30th, NCAA the night before decides to, okay, we'll make an interim policy, which essentially withdrew their prohibitions on allowing student athletes to do this. And July 1, 2021, which is the big date, is any student athlete, regardless if there was a bill in that state or not, was allowed to profit from their name, image, and likeness and still be eligible to play in collegiate sports. So that's just, really quick timeline of how it all happened. These are some of the states that, so this is, the first at July 1, 2021 effective date. Then you had the next wave added when this started coming down. They moved their date up, actually. So those two states did. We have additional 2022, 2023. So you can see it just kept going and going. And we had all this state legislation pop up to try to compete and make sure that their student athletes were able to profit from their name, image, and likeness.
So you can see that the state legislatures took matters into their own hands, and the significance of what the states did is very important to understand. Okay, essentially, states said, we are allowing you, student athletes within our state, to do what the NCAA specifically says you cannot do, and you will be ruled ineligible. It's a bold move for a state legislature to do. California started it. Florida really put the pressure on the NCAA by making a pretty quick effective date. Then the other states started to follow suit. Why did the other states follow? For recruiting purposes. They didn't want Florida, who was out there telling student athletes that our legislature is going to allow us and the businesses in our state to, to pay you for your name, image, and likeness, and to do things you've never been able to do. Alabama said, well, I don't like that advantage. Louisiana, Tennessee, and if you look at the states that had the very first effective date, you can kind of see a trend there with the red. So that's no coincidence. All right. When we were looking at the Supreme Court came down with a decision that, like CC said, it really was a blow to the NCAA's, whole principles of amateurism. They do not, they're trying to protect from players being paid, professional athletes. The idea of amateurism is that these athletes play sports as a pastime. Their education. That has been the basis of the NCAA's prohibition against student athletes doing a lot of different things. And it's been chipped away, years throughout the years. But the biggest one was several days before the states first had, the states with laws first went into effect. The day before, Florida and the rest of the 14 or so states had laws that were going to allow those student athletes to potentially violate on the book rules of the NCAA. The NCAA came out with an interim NIL policy. What that policy did was it sought to fix the issue that we had 14 states at that stage that had legislation that would allow something. The other states didn't have anything on the books that would allow their student athletes. So there was a major problem with the separation of states that gave those student athletes the right in their states with the states who hadn't taken any action. So what the NCAA did was they clarified that all student athletes do have the right to engage in NIL activities without potentially subjecting themselves to ineligibility. And they said to the states that do have legislation that was passed, they said, student athletes, you need to follow that law. If you're in a state that does not have a law, you need to follow your institution's policies or your conference's policies. How many institutions and states where the legislature hadn't already addressed this really had policies on the books? Not many. So it had general counsel, and you had institutions across the country that were scrambling, asking for other institutions from the SEC schools, you send us your policy. That was how a lot of that information was shared. But everyone was scrambling because the day before these laws went into effect, the NCAA allowed it. Okay. The next thing that the interim policy clarified was that student athletes can use professional services providers for NIL activities, which was a very important clarification. So that includes attorneys, financial advisors, and also the policy told student athletes that they are required, they should report all deals that they have in any contracts to their university. Okay. The biggest thing, if you're in compliance, you're well aware of this, and this is a rarity for the NCAA, but the NCAA said we will continue to do our normal regulatory operations and enforcement of our rules that are on the books, but don't come to us with NIL violations. We are not going to get into the business of interpreting 25 different states' laws and whether or not this student athlete complied or didn't comply. And we're also not going to interpret even more institutional policies. That was a major shift, and it really signaled kind of a decentralization of the NCAA on enforcement. The NCAA enforcement, they've never said, you guys figure it out and tell me if it's going to, if there's a violation or not, or report it. Okay. So that's on the eve. Well, I might have lost it here. There we go. So that was on the eve of, so that was June 30th. Okay. 12:01 on July 1st of this year, deals started to be announced, which obviously shows you deals were in the works before the NCAA waived it. Okay. But CeCe's going to just highlight a couple of the more high profile deals that you may or may not have heard of, just to give you a sense of maybe what kind of deals were done right out of the gate.
Yeah, and these are, like David said, the big ones that you probably saw in the news. So Olivia Dunn, the gymnast here, she signed as the first ever WME NIL NIL athlete, which WME is a huge professional agency. So she's the first collegiate member they've brought on, and she's actually projected to make the most money potentially out of any collegiate athlete. We have, Alabama quarterback Bryce Young struck a deal close to $1 million. Bo Nix at Auburn, we don't know the value of that one. A cool arrangement at Miami where a MMA gym offered the entire team a potential deal. If they want to come endorse the gym, they can do so. And, they do some social media posts. So like David said, these are the big ones, but most of these are not going to be of this magnitude. You're going to hear about these, but it's an opportunity for businesses to promote, using local athletes, and, maybe you give them credit at your store to post a picture. It's just a really cool way that businesses and student athletes can work together to, promote themselves and promote each other. So.
Yeah. So like CeCe said, those are the high, that's a small percentage of student athletes that have a market like that. Olivia Dunn has somewhere over, north of 5 million social media followers. That is what the businesses are seeing, that they can get more eyes on their advertisement or her endorsement of a product. So she's in a whole range that most of the student athletes are not in. There's not that type of money for the vast majority of student athletes or opportunities. These are the deals, the Gatorade, the Dr. Pepper. These are the big companies that are engaging in that. There is a lot of more creative in a smaller setting. There's restaurants that have offered deals that anytime that player comes in, they can eat for free as long as they post, something about the meal they just had. Okay, that's not going to change the athlete's life necessarily. It's not going to now suddenly, create all kind of. There are tax concerns which we'll talk about that no one else is really talking about. Student athletes certainly aren't thinking about. But I can guarantee you the IRS is thinking about a lot of these issues, especially these ones. And we will see the IRS come down at some point on somebody that, genuinely a 19-year-old who just didn't have someone making sure that they did report it and file it. So those are some danger areas that we're concerned of. So real quickly, we're going to just run through what our bill looks like. And again, remember the map of the states. Our bill is different than Alabama, that's different than Texas, that's different than Florida. There's a lot of similarities between them, but they all have some significant certain differences that if you are going to engage in this with a student athlete, you need to be aware of what the law requires here. This was introduced by Senator Connick and signed into law by the governor on July 1st. All right. The statute, first of all, it gives the student athletes the right to participate in name, image, and likeness activities, and it specifically prohibits the universities from unduly restricting those student athletes' rights to do that. So what that means is that if a university says, no, student athlete, you can't do that deal, that might result in litigation by that student athlete, might have the ability to then bring an action to say, under state law, I have that right, and I'm going to enforce that right. And a key word there obviously is unduly restrict. So there are some restrictions that are not unduly, and that therefore they're allowed to do. The legislature clarified that the university may not reduce the student athlete's scholarship. LSU cannot say, Olivia Dunn, we see you're doing pretty well in this NIL, market. And we're going to take your scholarship and give it to someone else who really needs it. They cannot take away their athletic scholarship. It does have some effects for some other aid that they receive based on, financial status. So the next important thing is that the universities cannot compensate a current or prospective student athlete for his or her name, image, and likeness directly or indirectly. Our state and all of the states put a separation. They specifically say that the university cannot pay the athlete to do deals for LSU, or they can't arrange them. That obviously extends to booster clubs. In our state, it does. So if you're involved with TAF and you're on the board, or you're of the Bengal Bells or the L Club, you are prohibited by law from directly paying a student athlete and engaging them. There's a million questions about how far does that go, but just know that pause if you're involved with them in a, you're on the board. Not if you're a booster. Everybody in this room is classified as a booster. Booster is the broadest definition you've ever seen. If you ever bought tickets to an LSU game, welcome. You're a booster of LSU. The law does not prohibit boosters from engaging and hiring a student athlete. It prohibits if you're an employee of the university, the athletic department, or you are a board or officer or director of a booster club as well. So they're trying to get a degree of separation there, which is important. Universities are also allowed to prohibit student athletes from using their name, image, and likeness if it conflicts with universities' current endorsement contracts, team contracts, or their values. Okay, very broad standard. What is Louisiana Tech's stated values versus LSU's or Nicholls State? So all of these are unanswered questions, but the law is giving the universities and institutions the ability to control certain areas of certain opportunities. One important aspect too is the legislature said it's important that we mandate a financial literacy and life skills workshop for at least 5 hours at the start of the student athlete's first and third academic years. Very important education piece. We'll see how effective that is, with any college age students and being told you have to sit through a literacy and life skills. Some are going to get it. It's going to benefit some. Others it's going to go right over their head. Our understanding from talking with universities across the state, most of them are already doing this and doing it more than the floor that's been set by the legislature, which is good to hear. Student athletes are prohibited by our law from endorsement of tobacco, alcohol, illegal substances or activities, banned athletic substances, or any form of gambling. Okay, this is one area you see some slight differences between the states and what are prohibited. Student athletes are prohibited in different states. One is adult entertainment is not included on this list, but a lot of the other states, Texas and the other states, have that industry. Okay, most of them though seem to have the alcohol, tobacco, and gambling prohibited. So if there's any alcohol, beverage companies in here, and you're looking to do a deal, you can't under Louisiana law. You might need to look to you might need to go to a state where they don't have a law in place, because you want to talk about the wild, wild west. That's where it just depends on the institution. Student athletes also are prohibited from using the protected intellectual property of the university. And this is where LSU and most of the schools, they will contact you and reach out to you. If that restaurant does take a picture with puts the LSU mark in the advertisement, student athletes wearing their LSU or any kind of protected mark, you will get a call from the universities, because that is very valuable. Those marks are very valuable to all the universities, and that is where we see the most concern and enforcement and phone calls from a brand or a restaurant. Because we've been told to take it down. We didn't even know we did anything wrong. Well, if you see that little LSU symbol there that you put at the end of that YouTube video, that's what you did. You need to remove that quickly. But LSU is very active, and the other institutions are very active in protecting that. Student athletes may, getting a little bit more into that, right? What does it mean to make money? It has to be, the compensation has to be equal to the market value of the athlete's name, image, and likeness. If anybody knows what that means, we'd welcome suggestions. I mean, the market value is typically what they're willing to pay. So there's a couple of objective measures that we've seen argued, is that if LeBron James would only get paid $80,000 to show up to the Rotary and give a talk, then paying an LSU football player $160,000 might not be the market value. It's clearly excessive. But still, I mean, the legislature has said there is some standard there, market value. We've yet to see anyone really make very persuasive arguments or to see how that's going to be enforced. The law puts the obligation on the student athlete to report the opportunity in the deal, the contract, okay? So as a business, if you engage or you enter into a contract with the student athlete, the law doesn't mandate that you have to notify the athletic department of the university of the deal. It puts it on the 19-year-old student. That is a massive headache for compliance departments already, but they want to know about these deals. They don't want to find out about them in the middle of a football game when it's on TV, especially if it conflicts with Louisiana law. So what we encourage is all businesses to remind those student athletes of their obligation. And even if you have a contract, to also put that they understand that this is part of their obligation under Louisiana law, and encourage them to do so. So we put together a couple concerns for the businesses here in the room. Some of you may be against this and think it's the worst thing. Some of you may be all for it. The reality is this is where we are today. Okay? This is an opportunity. There are a lot of positives coming out of this, and I think there's a lot of negatives that are going to come out of this. But this is the result of the NCAA's failure to act. This is the result of the NCAA not being able to get federal legislation in place that would unify all the states and at least equalize the rules here. But this is where it is, and there's a lot of good that can be done. There's a lot of stories that are coming out about student athletes. There's a lot of walk-ons that are getting full scholarships paid for. Now, there's a lot of baseball players here that are on quarter scholarships that now can legally be paid to attend a birthday party, of several 4-year-olds who think that this baseball player is Mr. Everything. Okay? They're not going to be paid $20,000, maybe $500 here or there. But you have opportunities here. A lot of times we think about football and the point guards and the shooting guards. We forget about the softball player who, when she finishes her last at bat, there is no next level. There is no professional league. She is finished. She's at the peak of her popularity and profitability in terms of endorsing products across the country. So, a lot of people want to jump on this quarterback who didn't have a good game after he got this deal, or our kicker who now has a pretty cheesy deal with Velveeta, but but everybody, until he starts shanking 50-yard, or starts shanking field goals, people are going to be very upset about that. And saying, instead of inking these deals, why weren't you kicking some extra field goals? So, there's going to be there's a lot of tension in that, but it's a lot of opportunity. The first thing that obviously you need to comply with Louisiana law, and your student athletes are likely not going to have representation. I mean, you are the sophisticated business involved in the transaction. So, it's important to understand that and to try to make sure that you're streamlining. No student athlete is going to hand you a contract and says, here's what my legal team proposes that we do. It's going to fall on the businesses to do, which is a cost to the businesses. Obviously, you can't deal with tobacco, alcohol, illegal substances, banned athletic substances, or any form of gambling. Another complicated aspect of this is, it cannot conflict with the already existing endorsements and contracts and team contracts. Most businesses have no idea who those are. So, that's why disclosure early on and good communication with the compliance department about the proposed deal goes a long way. You don't want to ink a deal and put out something and spend marketing cost and then suddenly have LSU tell you, well, we can't do that deal because we have a contract with Nike. So while we appreciate this, it would put us in breach of contract. So that's a complicated transaction on the, but good communication on the front end really helps that. We talked about just a few of the provisions in a contract you want to see, just reminding that this is done in compliance with Louisiana law, recognizing the student athlete's obligations. and specifically their obligation to disclose contracts to the university. A recent issue is popped up, and the question is whether or not disclosure of the terms of these deals are subject to disclosure under the Louisiana Public Records Law. So businesses and news organizations are interested to see the terms of the deals of all LSU athletes. They talk to a young attorney who says, I just learned about the Public Records Act. I'm going to send them a public records request. It's a public document that is in, let's say LSU's hands, that's required to be provided by statute. Does this document have to be disclosed under public records? Businesses have a lot of concerns about that. I mean, essentially, this is a business deal between a student athlete and also a business. A lot of times when they're writing the deal and writing things out, they're not thinking the fact that it could be subject to public record. So it's an issue that hasn't been addressed and answered yet. There will likely be a lawsuit probably filed in the next few weeks. I think most universities are taking the position that it's an educational record that's protected, and they're going to force a court to ultimately decide that. But if you are doing a deal, just understand it may be a public record. So you want to make sure that it paints you and your business in the proper light, is not trying to take advantage of a student athlete.
And just a couple other things we wanted to bring to attention is, like David said, you're dealing with, 18, 19-year-olds. What happens if they don't show up? What happens if they get hurt? Like we've already seen that happen with Miles Brennan. He inked 3 deals, got hurt the next day. He's not playing. So think about that from a business perspective. What happens if they don't get permission from the university? What if they don't disclose the contract? They're not, like David said, they're not the sophisticated party. So think about those as you approach any of these deals. There's a lot of liability on that side. So that's just one thing we wanted to bring to your attention. And the last thing we really wanted to bring up too is this use of institutional marks and logos. This is where the universities are going to be coming down. Like David said, the intellectual property is so highly respected, coveted at a university. It is worth a lot of money. So if they see the unauthorized use of it, they are going to come after you to make sure that that improper ad is taken down. So the statute does say, it has to be in accordance with the school policies, the use. So we went ahead and looked up just 2 of the schools, LSU and UL's policies as to how they're addressing this. So you have to get permission in writing from the athletic department prior to using this. So if you're thinking about using it, contact the compliance office there. This is what they're doing. This is what they're, there for. They want to know about this beforehand versus seeing the logo up there and then having to tell you to take it down and, we need to start from scratch. So same with ULL. They want everything prior and in writing. So intellectual property is something to really think about. Even if it's, you can associate it with LSU, like purple and gold, just the colors. Like that's something to really think about and make sure you get the permission beforehand versus have the university, knocking on your door. Hey, we got to take this deal down.
Yeah, and one last, I know I've been told that when the president stands, everyone will be leaving. So are you getting close to standing?
We got 5 minutes.
5 minutes? Okay, we'll let's take some questions. Does anybody have any questions? We have about 5 minutes left. Yes, sir.
How does this work in recruiting?
So it's, yeah.
So, we really want this guy, and he says, hey, if you come down, we'll give you $1 million contract.
Still a violation of the NCAA rules, and it still will subject the school, the booster, and also the student athlete, prospective student athlete, to potential problems. So
They have to be a student athlete at the time in order to negotiate.
Well, so yes, it cannot be used as a recruiting inducement, and it can also, it's not a pay for play. So you cannot structure a deal that says, I will pay you to do this as long as you continue to play for LSU, or you score this many touchdowns a game, or you do anything related to, in the Cade York example, it gets kind of tricky, but it's not about whether he makes it or misses it. Okay, but they're getting very close to that line. But it can't be about their athletic performance. It can't be contingent upon their athletic performance or their enrollment at your university. So that's, the NCAA has clarified that they will still enforce all of those issues. Now, when Nick Saban gets up to a podium in a room like this and mentions seemingly off the cuff that his quarterback, who hasn't even taken a snap yet, has already had $1 million worth of deals lined up. You better believe he's saying that as a recruiting inducement. He is letting the world know that's the market that we have. All right. There's nothing directly prohibited of that, but he cannot tell a student athlete that if you come here, this car dealership will, here's the deal, but you got to come here to get it. That would be a violation. But we're seeing, the line is less than crystal clear.
You talked a lot about the NCAA, but can you comment on how this is going to impact the high school student athletes?
Yeah, it's a great question, and we just had a session on Friday. That is coming, and most of, just in general, know that in Louisiana, the High School Athletic Association takes the position that it is prohibited by the LHSAA's rules. So if a high school student athlete does engage in one of these NIL deals, they will likely get a letter from the LHSAA ruling them to be ineligible. But they'll be challenged, and that one's coming too. It's a great point.
I have a question about the university. What if they use the athlete's image in promotion?
Still fine. It's a great. That's part of the third-party deals. Can only be third-party deals.
And an observation. I know you said that there won't be a lot of attorneys. I forget what the wording was there. That'll be the proposal. It seems to me that my husband's an attorney, that I should advise him he should get into this business.
Yeah, there's a lot of people that are just now learning and Googling NIL. So, there's a lot of opportunity. But these student athletes need representation. Businesses need representation. Universities and the big ones are fine, but the smaller schools really do need a lot of the resources that they don't have with outside counsel.
Yeah. Follow up with Tim. There's also been some accusations from smaller universities that bigger universities are contacting some of their athletes to say, especially with the transfer portal, that you can transfer
exactly
immediately. Right. That recruiting isn't about high schools. It's recruiting to smaller universities to get kids to come to the bigger universities, to bigger markets. So
right.
I think there's the wild, wild west.
Oh, it's all over the place.
Yeah.
This is, and that's why trademark issues, that's very clear. And they will, that's why not only is it valuable to universities, they know what the rules are and they will knock on your door and operate in that. Question back here first.
Yeah, David, thanks for the briefing. Is there any liability from a legal standpoint from other student athletes that are now playing professionally that said, hey, now these laws, like I'm Joe Burrow and I could have made a lot of money in college. Is there anything like that?
It's a great question. I believe that there's some challenges that have just been lodged already, kind of making that same argument. But I think they've got a lot of challenges and uphill battles to actually overcome that because the rules in effect at that time were being followed. But it's a great point.
Several years ago, Tom Brady said that he didn't do many advertisements because of its effect on the cohesion and the morale and the team's work. How is that working out with college?
It's an issue, but coaches are going to have to deal with it. The reality is that they already have a lot of those egos and problems inside of a locker room with the coaches talking about more to press conference and praising. Let's be honest, there's deals like this that have been going on for the last 50 years under the table. And the other players in the locker room, they understand that and know that. So there's a lot of that tension already there, but it is now a lot more in everyone's face, including when you have guys on the bench that could maybe have better opportunities than the starters. It certainly creates some tension.
You mentioned the player could not enter into agreement with somebody if the university already had a deal with them. Does it go the other way around? What if there's some other soda company that
that's a great
gets them first? Can the university they're barred from doing?
They're not under our statute. So I would say that they're not under our law. The law only allows the universities to restrict the student athlete's ability to enter into a contract. There's nothing about LSU or any of the other universities' ability to enter into that. So, but that is.
What would happen with the kids' deal with
they would likely stand, but it would be an issue. It's a great point, but this is why we love talking about it and can talk about it for about 8 hours, because everywhere you turn, there's some idea, and the compliance departments are seeing this on real time with real examples and trying to consult with general counsel to navigate this. But
it's kind of being reminded that the mission of the university is to educate.
Right. Did we not? That wasn't a slide. Right.
I thought I would ask if there's has there been any kind of discussion about somehow leveraging commissions to academic performance?
Yes.
Is that like nuts?
Yes. Well, yeah. Well, actually, the Alston case, and I'd be happy to talk about this more, but the Alston case really dealt with the NCAA's ability to restrict educational related benefits. They said that the NCAA does not have the ability to do that. And so now universities have the ability to give graduate degrees, to offer that to a student athlete. If you come here, here's a laptop. We're going to give all of our student athletes laptops. And if you're interested in law school, we will pay for your next 3 years. So it's sliding right under the NIL radar. But there's a lot of brand new territory with respect to educational related incentives as well. So thank you all very much and happy to talk about this. Anybody has any other questions?
Thank you, Cece and David. Meeting's adjourned.